Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode, The Appeal, we'll confront the stark reality of the Massachusetts criminal justice system's reluctance to acknowledge the deceptive practices of Judge David Ricciardone. The three-judge panel's refusal to scrutinize irrefutable evidence of deception during the plea bargaining process highlights a disturbing trend of turning a blind eye to constitutional violations. The invocation of Rule 23 not only sidesteps the critical examination of evidence, but also grants unwarranted deference to the sentencing judge's discretion, a discretion marred by deception and in direct violation of the law. In our previous episode, Motion for a New Trial, there was a notable absence of the Commonwealth's stance on the crucial issues surrounding my case. While the sentencing judge's response sidestepped any reference to the Commonwealth's perspective, the Commonwealth's position in the appeal process is opaque. The appeal panel vaguely alludes to the Commonwealth's argument, stating, and I quote, "We reject these claims for the reasons stated in the Commonwealth's brief," unquote. However, this stance leaves us to discern the intricacies of a legal landscape that denies a comprehensive understanding of the Commonwealth's perspective. I actually submitted a reply brief that was crafted with the assistance of someone experienced in appeals, elevating its quality beyond my initial pro se attempt. In this ongoing saga, it's crucial to emphasize that the focus isn't merely on my case, but on the pervasive deceptive practices entrenched in a system that shields itself from exposure. These practices, in direct violation of procedural rules and the law, create a distinct privilege for those within the system, setting them apart from the rest of us. This narrative sheds light on a broader issue, revealing a systemic problem that perpetuates injustice and undermines the very principles our legal system is supposed to uphold. It becomes evident that the deceptive practices within our legal system create a divide, turning constitutional rights and justice into mere illusions. And these illusions deny us something tangible to live by and to trust. It's a stark reminder that our pursuit of justice is an ongoing struggle against a system that often operates in opacity. Only through unveiling these practices can we strive for a justice system that is truly fair, transparent, and accountable to all. In this convoluted legal journey, we encounter a stark reality. The privilege extended to members of the judiciary, where, despite indisputable evidence of deceptive practices and fraud upon the court, the system shields its own. The glaring fraud by Judge David Ricciardone, whose actions during the sentencing colloquy, in clear violation of procedural rules and the law, become a focal point. Despite review of the transcript by the Massachusetts Appeals Court, the decision echoes with a concerning phrase, muddled in case law: special deference to the sentencing judge's discretion. This raises questions about the true nature of justice and fairness within the legal framework. And this privilege also extended to members of the bar, where despite irrefutable evidence of deceptive practices and fraud upon the court, the system shields its own. My case, investigated by the Massachusetts Committee for Public Counsel Services, exposes a dichotomy. While my specially appointed counsel committed blatant fraud, referencing her own suppressed evidence using deception during the lobby conference, she was honored with the prestigious Honorable Paul A. Chernoff servant of justice award. Meanwhile, I, who was denied counsel for post-conviction motions, found myself navigating a legal labyrinth alone. It unveils a predetermined outcome, emphasizing that justice, as it stands, is a privilege reserved for the few within the system, leaving an uneducated layperson to grapple with its complexities, disillusioned. And now, a word from our sponsor. This episode of Constitutional Fraud is brought to you by Massachusetts Appeals Court Rule 23. 1. Summary disposition without oral argument, which states, a panel of the justices of this court may determine that no substantial question of law is presented by the appeal, or that some clear error of law has been committed which has injuriously affected the substantial rights of the appellant, and may, by its written order, affirm, modify, or reverse the action of the court below. The panel need not provide an opportunity for oral argument before disposing of cases entered under this rule. You are about to bear witness to how this rule is employed by individuals lacking integrity, who wield the full power of our government to advance their personal agendas, shielding themselves in the process. Now back to our episode. As we find ourselves at the critical juncture in this legal odyssey, we stand before the Massachusetts Appeals Court, a bastion entrusted with the task of discerning clear errors of law. I presented them with a damning piece of evidence, coupled with a revealing affidavit. This 3-page motion to suppress evidence, which says that any in-court use is per se excluded as well. It was accompanied by this affidavit that clearly states, this affidavit unambiguously states, during the investigation, the investigating officer assessed the defendant's Facebook page and showed a picture from the Facebook page of the defendant standing next to his vehicle, unquote. The court minutes from the lobby conference, which I have right here, reveals a window into the orchestration of deception, an egregious act. In these minutes, my specially appointed counsel boldly states, and I quote, clearly having said that, just to mitigate, based on Mr. Toppi's own statement and the neighbor who identified my client from a Facebook photo that the police didn't see, in a picture of a car which, I have the picture of the car, I don't have the Facebook photo, puts himself there. The Commonwealth could clearly and successfully, I think, probably could succeed on a joint venture theory, end quote. Although the Superior Court failed to address the suppression motion, constituting an error in itself, my contention is not confined to this procedural lapse. It extends to the deliberate act of referencing evidence and distorting the truth, constituting an egregious attempt to manipulate the proceedings through fraud. This is not just a legal misstep, it is a clear violation of law. The appeals court's oversight in recognizing this profound error of law raises serious concerns about the integrity of the Massachusetts Appeals Court. And in the intricate tapestry, another glaring issue stands out. The presiding judge unequivocally assured the defendant on the record that he was adhering to established sentencing guidelines. However, the subsequent events laid bare a different reality. Violating Procedural Rule 12, governing plea bargaining, the judge engaged in direct negotiations with me on the terms of the sentence, employing deception to deliver a disparate judgment. The Massachusetts Sentencing Guidelines, outlined in Chapter 10, explicitly decree, and I quote, "When more than one offense arises out of the same criminal conduct, the governing offense is that crime in the highest level of seriousness pursuant to the sentencing guidelines grid. The governing offense will always be associated with the underlying sentence," unquote. The argument now becomes self-evident, as I was imprisoned on count 2 instead of count 1. The judge, in asserting compliance with established guidelines, resorted to deception in handing down a disparate sentence that was not in compliance with these established guidelines. This transgression isn't a mere procedural misstep. It represents a harmful, systematic error, and when emanating from the judge, a breach of ethics and law. Nothing short of a fraudulent act. This is a clear, undeniable instance of the judicial system itself perpetuating fraud. A betrayal of trust that strikes at the core of our justice system. Now, let's take a look at the Massachusetts Appeals Court panel's memorandum and order pursuant to Rule 23. Okay, this is their memorandum. At the very top, it is a notice that says, "Summary decisions issued by the Appeals Court pursuant to Massachusetts Appeals Court Rule 23, formerly known as Rule 128, are primarily directed to the parties and, therefore, may not fully address the facts of the case or the panel's decisional rationale. Moreover, such decisions are not circulated to the entire court and therefore represent only the views of the panel that decided the case. A summary decision pursuant to Rule 23, issued after February 25th, may be cited for its persuasive value, but because of the limitations noted above, not as binding precedent." All right, and I'm going to be reading it out of this. The defendant, William Toppi. First of all, let me introduce the panel. This is Judge Sachs, Judge Hershfang, and Judge Hand, who I watched on YouTube before I filed my appeal, and I thought very highly of them as very intelligent and men and women of integrity. However, I was wrong. The defendant, William Toppi, appeals from a Superior Court judge's denial of his motion for a new trial, claiming that the judge accepted his guilty plea in violation of his federal and state constitutional rights. The plea judge denied the motion without a hearing. In this appeal, the defendant argues that the plea judge should have allowed his motion because, among other things, plea counsel perpetrated a fraud upon the court and provided him ineffective assistance of counsel, and the defendant's absence from a lobby conference held before he entered his plea was improper. We affirm. They go over the background, and then they mention the legal standard. A motion for a new trial may be granted if it appears that justice may not have been done. Mass Rules of Criminal Procedure 30B. We examine the granting or denial of a new trial motion only to determine whether there has been a significant error of law or other abuse of discretion. A motion for a new trial is addressed to the sound discretion of the judge and is granted only in extraordinary circumstances. Whereas here, the motion judge and the plea judge were one and the same, we extend special deference. Rule 30 requires a judge hearing a new trial motion to decide, quote, whether the defendant's motion and affidavits present a substantial issue. In making this determination, a motion judge need not accept statements in the defendant's affidavit as true, even if the statements are undisputed. Instead, a motion judge should consider both the seriousness of the issue itself and the adequacy of the defendant's showing on that issue. Although the defendant's motion and affidavits need not prove the issue raised, to be adequate, they must at least contain sufficient credible information to cast doubt on the issue. If a motion judge finds that the motion and the affidavits do not present a substantial issue, then the judge may rule on a motion for a new trial without an evidentiary hearing. Then they go on their discussion. In his motion for a new trial, the defendant stated that his plea was taken in violation of his rights secured under the constitutions and laws under the United States and the Commonwealth of Massachusetts. With his motion, the defendant submitted affidavits claiming that he had been denied the right to effective counsel, fraud was used to induce a guilty plea from him, and his conviction was a miscarriage of justice. Since the defendant's motion and attached affidavits contained only conclusory declarations of constitutional violations, fraud, ineffective counsel, and a miscarriage of justice, but lacked sufficient credible information to cast doubt on the issues, the plea judge's conclusion that the defendant had not raised a substantial issue was well within his discretion. Were we to attempt to address the defendant's claims, our conclusions would be no different. Taking his first claim as an example, Toppi maintains that his counsel was ineffective and perpetrated a fraud upon the court. We disagree. A successful claim for ineffective assistance of counsel requires the defendant to show that 1, counsel's performance fell measurably below that which might be expected from an ordinary fallible lawyer, and 2, such conduct deprived him of an otherwise available substantial ground of defense. Having reviewed the transcripts of the lobby conference and plea hearing, as well as the submissions from plea counsel, we encountered nothing that rises to that level. Indeed, plea counsel advocate forcefully for a lower sentence and endeavored to have the sentence attached to the lesser of the indictments. The plea judge carefully confirmed that the defendant knowingly, intelligently, and voluntarily waived his trial rights, and that he did so with the access to the advice from plea counsel. The remainder of the defendant's claims on appeal are similarly flawed, including his claim of torture, improper participation by a non-party at the sentencing hearing, excessive bail, irregularities in the procedure for setting the amount of restitution, and bias on the part of the plea judge. To the extent that they rise to the level of appellate argument, we reject these claims substantially for the reasons stated in the Commonwealth's brief. Without more than factually and legally unsupported accusations from the defendant, it was not error to deny the defendant's motion. Order denying motion for a new trial affirmed by the court, Judge Sachs, Hand, and Hershfang, entered March 25th, 2022. All right. As evident from the appeal panel's response, the critical issues I raised regarding the sentencing judge's deceptive practices and the violations of Procedural Rule 12 were unfortunately overlooked and labeled as bias accusations. In a disheartening turn of events, this appeal panel, seemingly brushed aside the compelling evidence and dismissed it, as if the law only served to facilitate a fraudulent prosecution rather than to offer protection. I then pressed forward and filed a motion with the Massachusetts Supreme Court seeking a higher review. But regrettably, my plea for further examination was swiftly denied. I got this email, just simply stating, what does it say? Notice of denial of application for further appellate review. Please take note that on May 12, 2022, the application for further appellate review was denied. Stay tuned for our next episode of the series entitled Writ of Certiorari, where I petition our United States Supreme Court to step in and maintain the integrity of the Massachusetts justice system. I'm your host, William Toppi. Our pursuit of justice will begin with you.